consultant portfolio also. So welcome, Daphne. We're very excited to have you. And I don't know if we should still give some time or we should kick off immediately. Yesterday we started, I think, around 8:05, 8:08. Or what do you want us to give some time for more people to join, or you want to start immediately? Daphne, I think something is wrong with your audio. We can't hear you from my end. I can't hear you from me. Okay, I still can't hear you, Daphne, and I can see you're not muted actually. So please, I don't know. Are you using AirPods? Just confirm if they're connected. And yeah, we have some people in the comment section saying we should start. And once again, for data privacy purposes, please be reminded that you're being recorded. This call is a recorded call, and if you're not comfortable being on the call while it's being recorded, you can exit. Yes, Daphne, I can hear you, and we can hear you,
So
and I'm
sorry.
sure we're ready to
Apologies.
start.
I was saying I was gonna defer to you. I don't know if you want to start or wait like some minutes more. So I was gonna defer to you.
Okay, I think we should just go ahead and start. I mean, since we're recording, we'll make the recording available. Let's just go ahead and start so that we can keep to time. Yeah. Thank you.
Hi everyone. Can we take the poll now? Is it possible before I start my session?
Yes, it's possible. If, as a matter of fact, I completely forgot, we wanted to actually do a review of just play a short review of what we did yesterday. But
Okay.
Wale, are you on the call? Can we still do that before we take the poll? I can see the poll has already popped up. So as we can see on our screen, I'll be talking about legal structure, the implications of these legal structure and post-incorporation activities. It's a 3 days webinar, and we're going to start from the very basics. So this is just an introductory part of it before we kick off to the more serious activities. So first, I asked the question, what is a legal structure? I mean, it's basically the structure that your business takes, or the framework that determines the ownership, the tax obligations, and the liability, and how you can raise funds as a business. So going forward, what are the types of legal structures in Nigeria? You have the sole proprietorship, which is the one we're very familiar with. You register a business name. Some people call it enterprise or venture or whatever, but that's the one that doesn't end with LTD or LTDG or any suffix. Post-incorporation activities and requirements, because most people don't know the things that they can still do when they have their businesses registered.
These are the areas we are going to be talking about today. So what is bookkeeping? This whole word bookkeeping, what is it about? And why do we have to keep our books? There was a difference between accounting and bookkeeping, because I get people confuse both of them, right? Then I wanted to drill down for accounting for product businesses. So if you're a business owner that has product, the kind of books that you keep is a bit more than what a service business would keep. A standard service business would keep the standard books, but for your business, there are things that you need to take into consideration. And also knowing the best bookkeeping structure or the preference you should have for your business, right? Every business is different, even if you are in the same industry. And also your focus is different. So depending on your focus and your goals, your bookkeeping is also going to help with that. Then how do you use these numbers, right? They say know your numbers, know your numbers. Okay, so now you kept your books, you have the numbers, how do you use it?
So thank you very much. That was a short recap of what we did yesterday, and we'll kick off immediately now. Before we go ahead, we have a poll. Daphne wants to start with a poll that she would like all of us to participate in. Please, can the poll come up? Thank you. Daphne, over to you, please.
Okay, thank you very much. Is it possible to see the poll result? Okay, I think, uh, okay. Hi, everyone. My name is Daphne Epe, and I'm trying to look at the poll results. Okay. So I see for the first question, should I wait for the technical team to be done with the poll? Can technical team confirm, please?
So I think the poll is ongoing. If you just tell us when you want us to end it, and they would end it. But I think people are
Okay.
still kind of, yeah.
Okay, so I'll like 2 minutes extra. I mean, 2 to 3 minutes extra. Then the poll they can end the poll and then display the results. That works.
All right, that's fine. We have 24 people on the call, and about 14 or 15 people have taken the poll. So I don't know. And it's
Okay. Can we close it now?
yeah.
Okay, 22.
Yes. I think
Yeah.
we can work with this. Yeah.
Yes. Okay, great. So hi everyone. And I asked for the poll. My name is Daphne once again, and I asked for the poll just to get a sense of where everyone is when it comes to IP. So the first one, have you registered? So it's good to know that we have some persons who have registered at least one form of IP, be it trademark, patent, or copyright. And then for the second question, okay. So we have higher percent on for the trademark side, okay? And then the third question, which is, do you believe IP can directly impact your business growth? Okay, I'm happy about this one. More persons believe so, yes. And then challenges. Okay, thank you very much. So we could stop sharing poll results. And I'm going to share my slides. Okay. Great. Just to confirm, do you have visuals on my slides?
Yes, we can see your slides. Yeah.
Okay. All right, thank you. So mastering the fine prints, and we're basically discussing how early stage entrepreneurs and startups can leverage the tool of IP protection for long-term success. Okay, so basically, I'll be running through for this presentation, I'll be running through or giving a background as to IP to help us understand the concepts. I'm going to take us through the different forms, talk about how to, maintain practical steps, and then talk about how the impact on business growth. So for to make it simple or to break it down, I like to divide the phrase into two. One is intellectual, the second is property. So I'll be using IP for short during the presentation. So I always tell people this so that it doesn't look like an abstract concept, because often I know people say IP is quite abstract. I don't think it's abstract. So when you think of property, right, you think of buildings, like what you can see, right, what you can touch. But we're talking about intangible asset here. It is not tangible because you clearly cannot see it. We're working with operation or creations of the mind. But if you break it down to property, right, and then which means ownership, meaning that you own something, right, and then you break the second one, intellectual, which means you're working with your brains, right. Now together, it gives you the definition of IP. When we say creations of the mind, we're talking about inventions, literary, artistic work, design, symbols, basically used in commerce, right? Like I said, it is intangible, but I always use this phrase to say it's everywhere you go. So if you look in your house, probably have a book, and you look at the book, that what is written out in the book, the literary work, is someone's IP, right? When you look at maybe like you have like picture paintings or like designs on your wall, or artistic designs, that's basically IP. And when you look around your house, several products you have, like you see brands, even your phone, oh, Samsung, Techno, that's basically like brand names, and that's trademark and it's IP. So it is not abstract, it is everywhere. Like you can literally like you don't have to see it, right? But you are working with what people have put in their time or invested or entrepreneurs, as have probably created over time. So why does it matter, right? It matters because it is important to protect your IP because you want to control like how so for example, you want to control how your brand is being used. For example, Apple is not gonna let anyhow, like brand use something that's close to Apple for electronics or technology. No. It's the same way Coca-Cola is not gonna let anybody just come up with a drink today and call it Coca-Cola. No, basically they want to have control. And the reason why, businesses when coming up or other people will steal from those brands is because they know that okay, these people have strong protection mechanism. So what IP does is it gives you exclusive rights over your invention or your creation or your brand name. And then also you get to control you also benefit financially from it because like the more your brand is protected, right, it can result into financial impact. I'll talk about it more in details about licensing, franchising, and how you can, like benefit financially. But just think of it this way. When you think of big brands, right? You think brands that are international. What you need to know is that these brands have several layers of forms of IP rights. And the more they are able to build their IP right or build their market presence through their IP right, the more they can get financial advantage from their creation or their work. So who are the key stakeholders involved in the IP system or in the IP community? You have like yourselves, businesses, entrepreneurs, startup. You have like people like me or other lawyers who are like the ones working in the IP space. You also have the government bodies. So WIPO is the World IP Organization, and that's an international umbrella. Of course, it has like presence in every like most countries that are members to the WIPO Treaty, and Nigeria is a current treaty member too. So they have an office to Nigeria. And then you're talking about Nigerian IP offices. So you have the Trademark Patent and Design Registry, and then you have the Nigerian Copyright Commission. These are like the bodies that you interface with when you have to do registration or renewal of your trademarks or your copyrights. So I wanted to point this out, because when it comes to IP, it is territorial. What I mean by territorial is it's based on the country, right? So China is a different country, US is a different country, Nigeria is a different country, and your rights are based on what you have in the country. So the moment you want to expand your market to the international space, you then have to consider getting exclusive rights in these countries. So for example, if you have a registered trademark in Nigeria, sorry to break this news to you, your exclusive right is limited to just the Nigerian market. If you want a wider coverage, so depending on your market, if you know you have consumers or you are selling to across multiple jurisdictions, then you want to ensure that okay, you have your trademark protected in these countries, right? And I will talk in details about like so there are some treaties, right? International treaties, right? That makes international filings easier, right? And less costly. And I might speak to that in my later slides, right? But I want us to know that what these treaties or what they do is just to give you a system by which you can get like multiple filings like in different countries. It doesn't mean that, oh, because you have under like let me say one of them Madrid Protocol, it doesn't mean that because you registered the Madrid Protocol, maybe a trademark there, it doesn't mean you have in all the countries under the Madrid Protocol. No, because the system will allow you to pick what countries do you want to register in. And it just gives you like to save more money, right? Instead of having to get a lawyer in each of these countries to help you and, file. But that's on a global view, right? But just to let you know that when it comes to IP, we say it's territorial and it's based on the market presence. Where are you, as a business entrepreneur, where is your market focused on? Is it in Nigeria? Is it beyond Nigeria? And then so you get to think globally if you want to expand. So for the forms of IP protection, right, we have patents. I see that most people mention trademarks, which I'll come to, but I'll start with patent, right? So patent is basically covering inventions and innovations, right? And this is being governed by the Nigerian Patent and Design Act. So basically for patent, we have what we say it is based, like there are 3 steps to patent, right? To get a patent. One is the novelty test, meaning that your invention, what you're bringing must be new, it must be novel. Like it must not be something that already exists in the market. Don't forget, you're gonna be getting exclusive right over this thing. So for the government body in charge or whoever is going to review your application for your patent, you need to see that you have met the novelty test, meaning that it is new. So we have something called prior use, right? Or prior act, as it's called for patent. What it means is most time people come up when clients, just approach me and say, hey, I have an invention, I want to get a patent over it. We tend to conduct a search because you need to go and search, to see if there's a prior act. And prior act means somebody has come up with this thing before. So you can't just claim novelty. If you worked upon a prior act, you must be able to distinguish what's the difference between the prior act existing in the market and what you're bringing in. And then there must be inventive steps. So they need to see that, okay, did you just, how do I put this? So basically, you need to point out when you're drafting the patent application, right? You need to explain to the examiner that I took step 1, step 2, step 3 to come up with this invention. So it must be quite detailed to say, maybe I did my R&D, design, right? I did some research in the market, right? I came up with this. Oh, I know this exists. This is what makes it new. So it's basically saying we want to see that you do some inventive steps. And then they want to also see that we say, and that third factor is what is called, it must be useful. That's why it's called utility patent. But the useful is not just in the sense of being useful to like you and I particularly. It means that it's useful in the sense that if we look at where your patent application is and somebody in that industry of knowledge were to apply such step, they will be able to create that same invention. And that's where the utility comes from for patent. And then, so it is granted for 20 years because of how you can imagine how the patent works, right? There's a need to also put it, right? So they'll give you 20 years and, they feel that within 20 years, you should be able to monopolize the market, make your money off these patents before that 20 years. But of course, you have to pay like annuities every year because if you don't pay annuities from your filing date, you don't maintain the patent and basically you're forgoing your rights. But yes, this patent will cover inventions, innovations. Make it simple, like the simple terms. When you think of like appliances, like medical devices or maybe electronics appliances that are like new, it's like the kind of items that you will be taking patent like protection over. The next one is trademarks, right? Trademarks protect like brand identity. This one is very simple to break down. We're talking about anything like if it's a name or a logo or a slogan that you use with your business, right? How do you project your business? So how do you make your business distinctive from your other competitors in your space? So now in the like telecommunications, right, or in the phone, whatever, you have like Apple, right? Apple is known for the iPhone, right? Then you have Samsung known for their phones. When you see the Apple logo, everybody knows that that's Apple. Why? I mean, Apple is a fruit technically, but it's because they have put in years into their brand, right? To distinguish that brand, say, hey, our brand is known for, the for what's it called, for devices and all this like things related to this, right? And not a fruit. So for trademarks, right? Think of it this way. It's like saying I want to launch maybe a new clothing line, right? And I want to call it, just an example, I want to call it like DM as my brand name. I want the nearest future when you pass by a store and you see DM, you say, oh, okay, I can identify this is the particular brand. They are known for this particular type of clothing items. What it means is that I have to put in the work into getting my trademark, right? And then I have to also like use my trademark in the right way. So I like to explain this thing between registered and unregistered trademarks, right? For registered trademarks, it means that you have registered with the particular body in that country. Like in Nigeria now, you registered with the registry in charge of getting that registration. Something called unregistered trademark. What it means is that you're basically using your mark in the market, right? You don't have a restriction over your trademark. but through your use. So when you say when you say the word TM, so let's point this out for practical to correct these people. When you use the word TM beside your name, your brand name, TM means it's not registered. It just means, okay, it's either you have filed an application that is pending or you haven't filed at all. You have lesser protection in the market compared to when you register a trademark, because under the act, right, it will give you more leverage. If you were to go down the path of infringement, let's say somebody is compromising your trademark, you have broader rights when you have a registered trademark. And it applies to most countries, like even US or China. When you have a registered trademark, you have more rights than unregistered trademark. So yes, you could use unregistered to start building your name. But I always tell people that from the very beginning, right, like for most entrepreneurs, try to think ahead of registering your trademark, because in some cases, some persons that have built a brand, they start using a particular name, right? And they've been using that brand. And when they now try to get the registration, the problem we have is that maybe when we search, it might be too generic, because when it's generic, you're not going to get an exclusive right. Nobody's going to give for a generic term in your industry. So, for example, I can't come and say clothing is my trademark, right? It's known in the fashion clothing. So, if it's too generic, you'll not give you. Sometimes it is descriptive. There's this kind of sort of arguing between what is descriptive and suggested trademark, but I'll not even go into that to bore you. But basically, my point is, if you start early, when you start the brand, you search, is this name available? Or is it available in market space? Let me now get my registered trademark and then build my brand around it. That gives you more, that places you as a frontier in your market space than somebody who has spent their time on, because some part to rebrand. And the money end up like they end up wasting money because they have to rebrand. It's not available, it's not available. If we search the trademark registrar and they say, oh, this name cannot use because there's a similar name that's confusing or the generic name, nothing you can do. So it's like saying you build and then you start from the scratch again. So for the validity, trademark is like, as long as you renew your trademark, like you keep it in force, it's like it could be for like a lifetime, but it's based on you renewing. So if you give it the trademark first, it is 7 years from the initial period. Then you now have like renewable period of 14 years, 14 years, 14 years interval. I know several people here might register their trademark, but I'm sure they don't know that you have to renew your trademark. So please check it. If you have a trademark registered in Nigeria, now check the certificate for the dates and see when it's due for renewal. If you don't renew it, you've lost that trademark, and that's just the sad part about it. And it's being governed by the Trademark Act. We have the copyrights. Copyright basically will protect like artistic books, and like when you think of books, artistic works, that's where you come under the copyright, right? And then now we also protect software under copyright. So and that's one thing I want to clarify to most people. Software is not a patent. I see clients come and tell me, oh, I have a software, it's not a patent, it's under the copyright side. And basically for copyright, it's for the lifetime of the author. And then even after the lifetime, they give you 70 years. I mean, that's a very long time, right? And for copyright, you don't really have any renewal. It is yours. It is just basically getting the top requirement. Right? It's talking about originality. If you say it must be, it's not so high like in a patent where they are very keen, right? But they expect some minimum from originality. So if I see your literary work, at least let me see that you express, maybe you came up with a movie, right? And then the plot. By seeing your plot or how the layout of your movie is, I can see something that shows originality. Because oh, was it you that did you write the story yourself? If you used somebody that was work for hire, do you have an agreement saying that you own the copyright? So the type of thing that they delve into copyright ownership. If you can tell you own it, right? Or you wrote this book, right? You have authorship, it's original to an extent. Then you have to fix in the medium. So when you say fix in the medium, I explained in the beginning that so IP does not protect ideas. I like to explain this to everybody. Like it protects your creation. So move from idea to creation. So if you are, let's say you are in the movie industry and maybe you write movie scripts, right? And you are sleeping one day and you wake up with this inspiration of one amazing movie that is in your head. It is beautiful to know that. But the same way I think of that idea, what if I talk about the idea too? Ideas in my head, ideas in your head is in different like so for you to move to creation, then you pen down that story. Don't pen it down, put it in some medium. Then you have secured what we call like a common law clearance. You can now go the extra step to register your copyright to the Nigerian Copyright Commission. That way you get extra right, like full border protection. You have a certificate. If you were to go to court to contest infringement, you can present as an evidence. And that alone is giving you broader rights than that when you don't have a registered copyright. But like I said, the moment you come up with that creative work and you put down a fixed medium, if you draw it, make that drawing, you already have a copyright. From the moment it's fixed in the medium and it's original, you have a copyright. But if you go ahead to register your copyright, it gives you broader protection. For industrial design, talking about protecting unique designs that apply to products. That one is given for like 15 years. It's just 15 years, like the patent. But you have a renewable term. So it's like 5 years, you renew at the 5th year, at the 10th year, and then you're done. You don't have to renew subsequently. And then for trade secrets, so trade secrets basically protect your confidential business information. This is one that we say there is no registration. You don't register it. It's just you and you alone. The thing with trade secrets is if you can make it like a secret, as the word says, meaning that if your competitor or anybody accesses it and uses it for their benefit, it's not like a trade secret. I will delve into how we can, like, in terms of protecting the trade secret further when I discuss the NGs. For maintaining your IP right, like I mentioned earlier, I've said it before. So for trademark registrations, try to do periodic renewals, like for patents, annuities. For industrial design, renew at the period required. This is for renewal. For the copyright, like trade secret, you don't need renewals. But another thing is called monitoring. If you have an IP right, you need to monitor. If you're not just registered trademark in, let's say Nigeria, right? Not so that's a local way. For the local for people using your brands, like as long as your brand is growing, the more successful your brand gets, people want to do knockoffs. So you have to be visible, right? I don't know for those if anybody is doing international markets. I think the persons might have like I don't know, you know, be thinking of going global and maybe selling like with Amazon, you know, Amazon like maybe in the US or something. You see, when it comes to Amazon, people that know about Amazon in the US, you see plenty of knockoff designs. And some people that invested money into their trademark or their brand name and it's being used by their people who are not even people are disguising. Somebody is using your brand to sell. If not going to you, the original owner is going to be infringer. So you need to be like proactive steps, like watch out for it. And then of course, if there's an infringement, you have to like take steps. You can't just fold your hands. Like then you might need to collaborate with IP lawyers. That's the truth. You know, it's easier for you to consult with lawyers who do this thing, like IP practitioners like myself, to know okay, what can I do as 1, 2, 3 steps. But again, if you are based on building knowledge, right? Like I mentioned WIPO, if you go to WIPO website, WIPO has like several tools, like it has like even knowledge explaining from the basics to you. And they have this thing called an arbitration and mediation center. They make it easier for you to resolve your IP dispute. Like instead of going to court, it can take time and everything. It's easier to go through this route. But again, another way you can do it, I'll say is cease and desist. If you want to get a lawyer, maybe you want to do your own. If you see that somebody is in your mark that is infringing or your work as an infringement, the first thing you want to do is to write a letter, is positive and this letter and say, hey, I noticed this and this and this. Okay, I have this and this established rights. You are using my mark. Please desist from it. Give the person a timeline. If you do that, I will take the next step, which is like going to court or through the arbitration method. But basically, you own it. It is your property. So you also have to be intentional. The way you're intentional about your houses, like your cars, you put in intentionality into your IP right because it affects your business growth. It can impede your business growth and it can, you know, improve your business growth. So when the next subject is the role of NDAs. It's called non-disclosure agreements, NDA for short. It's basically a legal contract that you use to ensure confidentiality of shared information. Now this works with trade secrets, and this is very keen for us, right? Um, you know, I once had this client who had this very, let me say, brilliant invention, right? And it was in the food tech industry in Nigeria, and I think like 2 years ago. And basically, you know, startup, right? Sometimes you're trying to grow this thing and you just need to get investors. So this client basically, you know, had put something down, right? But needed to get investors. And the person made a pitch to an investor, right? But did not do the let me say the legal steps like this, like use an NDA. And I was explaining why. Just went ahead to say to make a business pitch. And that was the biggest mistake ever. Because some of these investors have the money, will take your idea from you, work on your idea, and use the idea to make their money. And really, what's the proof to say it's my idea? The person had not secured the patent over this invention, like I mentioned, did not have an IP right registered, did not use an NDA, and basically was now facing, like, wanted to fight. What are we fighting with? So this NDAs now is for mostly you as an entrepreneur. If you know that you want to discuss with your investors, right, about your business, right, before you share anything that is called confidential, and this also works with your trade secrets. If you know something is very unique to your business that you don't want to go out there, or you know that these steps is what you need to do. You haven't registered a patent, for example, or gotten the IP right. The first thing you have to do is to sign an NDA with that person. And very important for your NDA. Your NDA, what's very important is the NDA should, the definition of what is confidential, I should say it includes all proprietary information. So when you define your NDA, when you define that in the definition of the NDA, right? When you describe what's called confidential, you put in there that any proprietary information or asset that is being shared to this person. So when you make it so broad enough, it means that everything you have discussed with the person is trying to not use it. That it means you can't disclose. Do you know what I mean? So when you say duration, you want to peg it for like how many number of years. So that way, if I discuss my unique idea with you, right, I've tied you down for this particular amount of years. And within that years, I would have probably taken like 1 or 2 steps to grow it and secure my IP right over it. And that way you are protected. So my point is, before you discuss what is unique to you, before you go about and you haven't gotten a patent, for example, or maybe you're trying to break down this trade secret, right? So if you drink Pepsi and drink Coca-Cola, there's not a difference. I'm a Coke fan, so I can tell there's a difference. I think everybody can tell. This is one of the brands that have been able to maintain trade secret for years because it's a unique way of making that drink. Nobody knows about it. It is called a trade secret, and they have kept their recipe for years. So if you run a food business or restaurants, right, and you have this particular recipe that is very unique to you, that recipe is not what you're going to copyright or something. You're going to keep as a trade secret. But the truth behind trade secret is that it must not go out. Once it goes out, it goes to right. And this is where the NDA comes in of employees, contractors. If you have a trade secret and the person needs to work with your recipe, you will sign the NDA, and the NDA will bound you to say, oh, you cannot disclose solution out. Even after your employment contracts, you are still tied to, not disclosing it out. So basically, make your NDA friend. If you are a startup or want to make an idea to an investor, apply this investor. I'm very passionate about this issue because I've seen several, and it's so sad to see several entrepreneurs who have lost their inventions to the big people in the industry, all because of looking for investors. So make your NDA your best friend, like keep it close to you before you disclose. What's the benefit of IP for entrepreneurs? I mean, let's talk about the benefit of IP. It is your competitive advantage. So, for example, like I mentioned, the trademark. Mark is what distinguishes you from your competitor. So if you look at what's it called, like I mentioned, like if you look at Apple, right? Look at Samsung, these are two different brands. You will know them by their name alone. And by their different logos, you will know them. So because they've built their business around this name, so meaning it differentiates you. So people to have advantage in any sector you are or where your business is operating, you need to think of how to get IP right. You could have one or two, depending on what you're doing. I mean, if it's only trademark you have, that's okay. If you're gonna invent something, patent. If you have things like literary work or like things that maybe like your software, then you think of what's it called? Copyrights. So people have different layers of protection depending on what is the innovation, right? And revenue. So you can also make money off your IP rights by licensing your IP to somebody. Like you make money. Like it's just very simple. I own exclusive rights, but I need this thing from you, right? I need this particular thing from you. Maybe I'm working on a patent. I need your license for this thing. I don't see the point of if I do a pirate search, you already have exclusive rights and I cannot get it. Now I need to get license from you. Then you begin to bargain and people sign like millions of money for depending on how big. So again, depending on how big your IP for portfolio is, then your license deal could be like running to more like multiple money. Now you can also tell it. You can say, oh, when I wanted to get this IP, I don't intend to use the name for myself. I don't use it in the first place. I just want to sell it off to somebody and when I'm done with it. Of course, that'll be more money. I'm giving you my exclusive, what I've put into like did the work. I secured the patent, for example. I have paid the annuities and I've put everything into consideration. And the years I've used, to maintain that IP rights. And then you sell it or you make money. So if you license or you sell, you make money. Investment attraction, like the bigger your IP portfolio is, the more you attract investors. Everybody wants to invest in your brand. That's the truth. When a brand is big, they want to invest in you. And the only way you can build your brand is because you have maintained that exclusive rights. And that comes with doing the right thing, getting your IP rights registered, maintaining your IP rights, using it in the right way. Let me just say this at this point. Please, if you're free a trademark, right, use the mark the way it is. So if, for example, I said my mark is DEM, I will use DEM. I have like a logo, a stylus version, right? And it's DEM. Use it the way it is. Not tomorrow, now use DME. If you don't use them, you change how you use your trademark, right? You also like give control in the marketplace. So it's building your brand. You are causing us to be confused. use it the way it is. If your mark is registered as, let me say, DEE, continue as DEE. So that's how you're going to build your portfolio. And then the last point on that benefits is global expansion, right? Like I mentioned, if you have it now, in the future you want to expand your brand, right? This is where IP can help you. And I mentioned about treaties. So we have the patent cooperation treaties. PCT is for patents. If you know that your invention will be used or be sold, not just in Nigeria, it will be sold in China and the US. When you file your patents in Nigeria, you file under the PCT track. At that point, you can select the countries you want to file under. So that what it means that the International Bureau will send your patent application to those countries you have designated for them to go through their own process of looking at, like I said, IP is territorial. So each country have their own specific rules, of course, for patents, but still around the core principles. And they also have, like, they have the core examiners in every country, in Nigeria, in any country, they have patent examiners. They examine to see that, okay, is it new? Is it novel? Does it infringe on any prior art set before they grant you your patent? So the PCT will make it easier for you because I think you are filing in Nigeria, you're speaking 2, 3 countries. So you're paying just their government fees in those countries. It's only when you have a case of what we call office actions where they give you a neutral provisional refusal. At that point, you might have to get a lawyer in those countries to help you to solve it, like resolve it. If you have a lawyer within Nigeria, you have with other associates in those countries to fix it for you. But yeah, it makes it easier for filing. We have the Madrid Protocol, but sadly, Nigeria is not yet a member to the Madrid Protocol. But I mean, if you're thinking of global brands, right, you could pick one country under the Madrid Protocol, and then when you file that trademark, you designate other countries too. It makes it very easier for you. If you are thinking, not be now, just for you to note that when you want to expand, right, please, if you want to expand beyond Nigeria, do not stop your IP rights at Nigeria. You have to get more protection in the global markets. And then impact of IP protection on business growth, like I mentioned now, you see, having IP assets create opportunities for franchising. So franchise, as opposed to license for licensing your IP right at that point, you're only concerned with, okay, for license, I don't have control over how you use my, whatever the invention is, right? I only have, so I'm only going to talk about the terms, right? If I'm giving my license for those 3 years, it means it's just 3 years license, right? And also how you pay me the money. Are you paying me like a lump sum? Are you paying me royalties like from time to time? These are like contract terms, basically. But in license, your goal is to give it off a particular period, right? Or you also have to determine, is it an exclusive license? I mean, will I give it to only you for that 3 years? If it's non-exclusive, it means for that 3 years, I can give it to you, give it to B, C, depending on our agreement, right? For franchise, it's like saying you want to control, right? So, and what you do for when you want to expand. So, you want to expand their business into that country, right? Sometimes you don't have the money or whatever to start opening the store, doing all the processing. So, some people come and ask you and say, well, I want to get a franchise in a different, like in another country, right? But I'm going to be using your trademark, your brand, and I'm using your recipes to do the franchise. So, you, as the person giving out the franchise, right, you have control because the contract will tell you the terms. How should you use my trademark? Because if I view my trademark in this particular way, you cannot use your franchise to spoil it for me. So I'll give you terms. So for franchise, you control more of how they use it to your business goals. But my point is, SP assets can give you also to decide franchise deal. Your portfolio determines how much of money you're going to be bagging, right? And like I said, it gives the opportunity to expand. Scaling means moving your operations beyond your country. For another factor is market trust. Market trust is basically saying, see, consumers will trust. People say big brands, big brands. People go for big brands or well-known brands because they're not scared of being scammed. Like, I've known this brand, it's been there for years, right? Like, think of your banks, First Bank in Nigeria, it's been there for years. I know the bank, and because I trust it, right, I want to patronize them. So it's the same way for you to get market trust. You need to, you need to invest into building your IP portfolio. Like, you need to invest into your trademark. Like I mentioned before, if your trademark is registered, use the R symbol. The R symbol is not the TM now. If it's not registered, use the TM. When you see that R and the circle, it means that it is a registered trademark. So that's another point to note. If you have a registered trademark, and if today you're not using the right way, please, if that's one point you will learn today, when you go check your website, your business pages, your correspondent, ensure it has the R symbol with the circle on it, right? And then if it's not registered, like I said, you can use the TM just to point and say, hey, I have a trademark, right? But it's unregistered. If your copyright is registered, you want to use the C, right? For the copyright notice. But Again, you use it in the right way so you can build your market trust. Spot opportunities. For this one, like if you're exporting your goods, what you sell to like other countries, you find out that there are some trade, like when it comes to like borders, there are some rules. But I can tell that most of the borders, right, they want to check if you have a registered trademark in that country or you got like your IP rights. If your IP rights are cleared and good to go, it makes your export easier, like smoother and easier if you're doing international trade or like global markets. And these are like some of the benefits, of building your IP assets, right? But just know, just just know that, like I mentioned in the beginning, your IP can impact your business, right? It is based on that portfolio. And I'll tell you, so when people are doing M&A, merger and acquisition deal, right? When they are doing the due diligence of M&A, the thing they want to check sometimes, one of the things they check is your IP portfolio. We have what we call IP due diligence. If I'm being hired for a counsel for as a counsel for a client who wants to acquire another company, right, an acquisition, or they want to merge, I'm going to be asking you for your IP portfolio documentation. I want to review it. That's what I'm going to use to bargain. For example, you tell me, oh, I have this trademark, and I go and check, and it has lapsed. You know, it's a trademark. You have a trademark. So you would shoot yourself with the leg if your due diligence is not complying because your IP portfolio is that lacking behind or it's not updated. So again, it's very important. Practical step for entrepreneurs, right? Just as takeaway points. Like I mentioned, now begin to think, look at your business. Are you in the entertainment space, right? Are you an author? Do you write books, right? Do you have like movies? Are you producing anything audiovisual, right? Do you sing? Do you have like music notes? Are you under the copyright regime? Or do you have a business where you sell goods or provide services? Do you have registered trademark? And don't forget, for trademark, it's based on the classes of goods and services. So if you register for just clothing, your right applies to just clothing. So now begin to think, if when I started my business, I was just doing clothing and I've expanded to other form of thing. Maybe I'm now doing what else again? Maybe I'm selling different kind of goods, right? You then want to update your registration to get more, to put your trademark in other classes of goods and services. And everybody I think across the world, everybody uses nice classification. NICE nice. It has like the whole class 1 to 45 if you want to know what they entail. But basically, class 1 to 34 is for goods, 35 to 45 is for services. So if you're already selling maybe goods before and you're selling services, you want to expand your trademark. So now begin to audit your IP. If you already have registered IP portfolio, check your patents. Do you have annuities that are coming up? Have you paid your annuities, or is your trademark due for renewal? If you haven't gotten, start to think of what are the IP rights in your business you can begin to acquire and how to use it. The next step will be to register your IP. Obviously, if you identify that, oh, I need a trademark, I need to get a patent, I need to get an industrial design, next step will be to register it. Leverage WIPO resources, like I mentioned. WIPO has like several resources, like even for traditional materials, like educating you, giving you more information beyond this webinar, and you can see things like the PCT I mentioned. You can see the Madrid protocol. It's a WIPO website. Also, collaborate with experts. I mean, you might need some IP attorneys and business advisors to guide you through. Like that's the practical step 1, 2, 3, 4. At this point, I feel like I'll be speaking, and I hope we all got something important, and I will take questions, if permitted.
Thank you very much, Daphne. I told you all that Daphne is ready. And this is not a basic or elementary class. She came with a master class material. Thank you very much, Daphne. Please, if you have any questions, as usual, I forgot to mention this at the beginning, please type it in the comment section and we'll address it. This is 8:45, so we ordinarily will just move on, but I don't know, maybe we'll give about 5 minutes. Definitely, maybe the first question there, you can just address it, and then whatever else is left, we'll address it on the page. Thank you again. Thank you. That was an amazing section. Yes, I agree with you, Deborah. All right. So you have your first question.
Yes,
you can
I
see the
see.
comments, right? Yeah. All right.
Yes, I can.
Please go.
Can you explain on how the IP the MBA and copyright apply to the fashion designer? So just to confirm, MBA, like, do you mean MBA as Nigerian Bar Association? Can the person please confirm? I
Sorry,
think
I
that's from
think this person is talking about NDA. I believe this
Oh,
should
okay,
be
maybe typo.
NDA.
Oh,
Yeah.
okay.
Yes.
Okay, I'm so confused. Okay. So like I mentioned, right, if you are a fashion designer, so that means you're maybe offering tailor custom like services like designing. So basically you must have a trademark, right? That's the one form of IP you need to have, and you need to register it in class for tailor custom making of clothes and dressing. But if you also make, like, let's say you have like ready wear clothes that you make and you sell off as goods, that's class 25 for clothing and goods item. So first is you need to know what's your brand name and what is that unique name you are using in the marketplace. If it's not registered, you want to register your trademark because, like I mentioned, what do I know you for, right? When you think of fashion, I think people know, like, top brands, right? Like, the Hermes Birkin bag, this particular designer, because they've built their what's it called? They've built their investment around or invested into their brand, their trademark. For the NDA, the NDA is basically going to be if you're going to share anything that is important, like confidential to your business. If you're going to maybe how you make your maybe how you make your corset dresses, you have a unique style to it. Like maybe you want to share with maybe your contractors or your employees, right? You want to bind them to an NDA. People, you can include an NDA even in your employment contracts. A short clause alone in that employment contract that has the NDA will bind your employees not to disclose that information at least for a while, even when they leave your business. For the copyright, to make like those designs, like your sketches, right? Your sketches for your design, but like I mentioned, it has to be like original. Like you can't just make what's already market and come and secure the copyright. But if you have your sketches, those your sketches, the designs, right, and they are very unique, you can then get the registration for it. And even if you don't have registration, just make sure that you sketch it out, right? So that means you have a copyright. And then like I mentioned, the copyright notice, always put the C with that symbol, and then put like, when you put the C, just put the year it was created. That's like putting a copyright notice to people or the public. So I think that I hope that answers the question. Should I take the next one? Can I? You're muted.
Sorry. Okay, you can take the next question because I'm trying to pull out the question so that we can just answer it on the page. But you can take
Oh,
the
okay.
next question and that will be, oh yeah, just take the next question. Let me pull out the remaining.
What's the next one? I think I saw. Okay, so this one says, please can we do the copyright registration? Oh, so if you go to the Nigerian Copyright Commission, like the website, right? You would see yes, you can actually. Yes, you can. You have to create an account with them. When you create an account, because if you're not, you can put an account. They like also offer services who are licensed, right? But you will be creating an account as the author of your work, right? And then you can then follow the steps. And I think they have like resource tools like a DIY for you to use, right? But if it's complicated for you, I'll say get an attorney. But if you can, it's possible to do yourself. Like just create it and then follow the step-by-step guide, to fill out your
Okay,
copyright
thank you very
application and
much.
send the
You
government
can
to.
still keep your questions coming in. Thank you so much, Daphne. You know that I don't take it for granted that you are here for us this night. I okay. I think I was thrown out of,
Yes.
I think the
It
network
went off.
just
I was
threw
trying
me
to
out
check
of the
it.
meeting. So sorry, everyone. So please, like what I was saying is that you should keep your keep your questions coming in. We will address it on the page, and without taking much of our time, we'll just go straight to the next presentation. Please, I would appreciate if we can give a round of applause for Daphne. Just use the reaction button, and appreciate Daphne, please, for taking out her time out of a very busy schedule to be here with us this night. Thank you so much, Daphne.
Thank you for having me.
Okay, so I'm trying to share my screen so that I can go ahead to my presentation immediately. Sorry, this is okay. Let me reshare. I'm not sure what's going on, but let me reshare. Okay, can you see my screen, please? Please, if you can see my screen, please confirm, and if you can hear me as well. Okay, thank you. Thank you very much, Deborah and Hafsa. Thank you so much for confirming. So let me just go right ahead. My presentation would be on using effective contracts to protect and scale your business. It's not that I think it's very straightforward. So let me just delve into it, and we'll finish. I won't take much time because we've already spent a lot of time. So why do we need contracts as founders and entrepreneurs? I like to say that contracts are not just paperwork, like people would say, but they are essential tools for building, protecting, and as well growing your business. Now, I didn't add this to my slide, but you know that contracts are not just written. You can have an oral contract or an oral agreement with somebody, but the problem is, I said, you said, when did you say, what did you say? I mean, so that's why it's always better to say, put your contracts in writing so that you can always track what has been said and what was agreed. Now, why do you need contracts as founders and entrepreneurs? First, it defines the roles and responsibilities in any dealings that you're doing. You know, every day we have interactions as human beings. You have arrangements with your siblings, you have agreements with your friends, you have even agreements with your parents. But because these are not commercial agreements where huge amounts of money is involved or business interests are involved, it doesn't matter if you guys have an issue, you fight over it, and wherever it ends, it ends. I mean, somebody says, oh, you never said that. Oh, I don't remember this being what I'm supposed to do. But when you have commercial agreements, then it becomes important for you to define the roles and responsibilities of each party so that I don't think this network likes me this night. Okay, let me just reshare my screen again, please. So sorry about this constant interruption. trying to also change my network provider. So maybe. Sorry, I'm trying to change my network provider. Maybe that would help. I'm not sure. Okay. So let me just pick up from where I left. And like I said, it protects your business interests, help you, or I mean, I'm not going to do much of this. Daphne has talked a lot about using an NDA, using contracts to protect your intellectual property, your trade secrets and all of that. So your business interest is protected, and it helps you to attract and retain investors. Of course, when you have proper founders or partnership agreements, it helps with your sharing, your ownership and all of that. And if you're bringing an investor, it's easy for them to plug in because they understand their rules and they also have confidence that you understand your role as well. And of course, it supports business growth. Contracts help you to attract partnership, franchise and grow, and so on and so forth. The last one, okay. So what makes a contract valid? I mean, anybody can pull up a document and call it a contract, right? You can write anything on a contract, but there are basically 6 elements of a valid contract. And those are, first, an offer. An offer is just a clear proposal by one party to the other. For example, the yellow bus driver in Lagos is calling Oshodi. He's making an offer to you. At what point do you accept that offer? At the point where you stop him and then enter his vehicle. So you've accepted that offer. And that brings us to the second element, which is acceptance, which is unconditional agreement by the other party to accept whatever offer that has been made to you. So to have a valid contract, first, somebody must have made an offer, and then another person must have accepted that offer. And the third is there must be some sort of consideration, something of value that is being exchanged. So someone is exchanging money, someone is exchanging services. So if there is nothing of value that is being exchanged, then there's no consideration and that contract is not valid. That's the implication. Now, the fourth one is the capacity of both parties. Do both parties have the capacity to enter into a legally binding contract? You cannot have an agreement with a minor, maybe a 3-year-old, to sell a house. I mean, that would be superfluous. You must enter into a contract with someone who has the capacity to enter into that contract. Same goes to the fact that you cannot have an agreement with a mad person. You cannot have an agreement with someone who is senile or someone who cannot think, who has a mental condition or something, because that contract will not be valid. And the fifth element is legality. The subject matter of that contract must be legal. So you can't have an agreement with someone to go and kill someone else and then expect that that contract is valid and is going to be enforceable if the other person says, oh, I'm not doing again, or the other person doesn't pay you the money you get from such illegal activity or from kidnapping or something, and then you come out and say, oh, it's a breach of contract, I'm taking you to court. Of course, the subject matter of that contract must be a legal activity. Now, the sixth element is intention to create legal relations. Now, this is a tricky one. You have all of these elements, but do you have the intention that whatever agreement you're entering into with that person will be legally binding? Do you have, for example, you have an agreement with your father that he's going to give you one of his houses. I mean, he told you, you accepted, maybe he even said, oh, for that, you have to get good grades in school, and you say, okay, that's some of consideration, and both of you are adults, so you have the capacity, and the subject is not exactly illegal, so you have these 5 elements. But then, was there an intention on the part of your father for that kind of agreement to be legally binding, or was he just saying it to motivate you to do well in school? So it's also an element for a contract to be binding that there must be an intention to create legal relations. I hope that was clear. So I'll move on to the next slide. Common types of contract that you must have come across or heard about. You have partnership or shareholders agreements, of course, that helps you to define ownership, roles, and all of that when it comes to having co-owners in a business. You have the employment contracts where you clarify the roles of your employees, make it clear who is who, what their job expectations and deliverables are, what they're entitled to, what their benefits are, and all of that. And of course, you can also, like Daphne mentioned, use your employment contract to protect your business from intellectual property theft by including some very essential clauses into that employment contract. Now, next, you have the service level agreements. Now, this one, basically, you use it to define deliverables. For example, you hire a contractor or someone to do someone, you want to define clearly, what am I expecting you to do? Maybe a graphic designer, I expect you to deliver so and so number of designs at this particular time. So you clarify expectations and deliverables and timelines, and of course, payment terms with a service level agreement. And then you have vendor supplier contracts, which of course you can have a contract with a supplier to send you goods and that you pay later and all of that. So you can use contracts. There are various kinds of contracts that you can have. You can have an agreement with your vendor, or you are the supplier, you can have an agreement with the people you supply and all of that. And just to make sure that they are giving you the right service. And for example, if something goes wrong, maybe you're buying a computer system for all your staff, and then you have an agreement that this person is going to supply you so and so number of computers, and that the person is supposed to come in, give you some warranty, maybe come in so and so number of months to come and check if the computers are working well. Or maybe if it's something that needs servicing, maybe vehicles, that the person is supposed to provide free servicing for the vehicles every month, and all of that. You can use a contract to manage all of this relationship. And of course, you have investment contracts where you're trying to bring in people into your business. You want to be sure that your equity is protected, not that you're bringing in people who are coming to invest and then they have arbitrary powers that they can literally wake up one day and kick you out of your business. And it happens a lot of times, but it's in the fine print, like the theme of today's meeting says. It's in the fine print. You can use your contracts to protect your interest and your equity. When I say equity, I mean your ownership in that company, even as you're bringing in investment and investors. Yeah. So what are the critical clauses to look out in any contract whatsoever? For example, you don't have before you even engage a lawyer, or you don't have access to a lawyer, or you don't want to engage a lawyer, what are the critical clauses that you must look out for in any contract? Now, I'm not talking about what the contract must have, maybe the names of the parties, the address of the parties, this, that. No, I'm talking about some critical clauses like the payment terms. You must ensure that the payment term is adequately captured so that you get your payments on time. And if there are any late payments, of course, you specify penalties, just something to incentivize the other party to make payments to you. And that's how you keep your cash flow. You use contracts to grow your business. Termination clauses. You don't want to get into a contract that you can't get out of. Trust me, this happens a lot of time. People don't like thinking about the end. Someone comes, brings in a good deal. The only thing you're seeing is how much is in it, how much is in this deal, how much am I going to make at this point in time. You're not looking at, if this thing choke me, if it hook me, if I can't deal with all of this anymore, if this person decides to be a thorn on my flesh, how do I get out of this agreement? So at the point of entering any agreement, any contract, always think about the end. The termination clause, is it properly captured in a way that you can leave that contract with your peace of mind without being sued, without being asked to pay some reckless damages and all of that? And of course, confidentiality clause, which is also related to intellectual property and trade secrets. You want to have some clauses in your agreements that you would use to protect what is unique to you and the sensitive information in your business. Now, I've had people ask me a lot of time that people say trade secrets a lot. What is trade secret? And I keep saying, what is unique to you? For example, Coca-Cola's recipe is a trade secret. There is nothing you want to do to get that recipe. It could be a restaurant. It could be something that is just that makes you different, or that differentiates you from the market, however you want to put it. But when you're employing people, of course, you give them access to, for example, you give them access to all of this because you want them to, because they're going to need those things to do the work. So, but do you have things in place like contracts, binding, legally enforceable contracts that makes it impossible for them to take that, your trade secret, and go and sell to a competitor or even use it to run on their own? And if they do that, is there any remedy for you? Are you protected? So that's what you can use. That's one of the critical clauses you should look out for in your contracts. And then indemnity clauses, you should know the extent of your liability. Don't expose yourself to unnecessary risk, unnecessary liabilities. I mean, we've looked at contracts that can even hold you responsible for a kind of estimated profit that someone does not make because you didn't do something. You know, that there's a way contracts are couched, and if you're not careful, you'll be signing to be responsible for a revenue that someone has not made, and profit that person has not made. And they said, oh, if for any reason you were unable to do something, and they're now causing them not to make this projected revenue or loss, you'll be held liable. So you should be able to use this, look out for whatever indemnity clause is in a contract, or even as a business owner, how are you limiting your liability, and how much liability and risk are you outsourcing to the other party that is entering a contract with you? Of course, you have force majeure clauses for unforeseen circumstances like natural disasters. And to 2019, 2020, when COVID-19 happened, a lot of businesses were lost because nobody knew how to move, what to say, or how to make any progress. Farmers, market persons, physical businesses that had physical stores, suppliers, most people were confused. And agreements that had timelines, most people didn't know how to go about them. But this is where you have force majeure clauses, where you define if something happens, maybe riots or natural disasters, pandemics, that makes it impossible for me to fulfill my obligations under this contract within so and so period. How do we go about it? What happens? So that way you provide for that and nothing catches you off guard. Of course, dispute resolution. Everybody is a friend at the beginning. You never really foresee that anything is going to go wrong, but it's always, like I like to say, it's always very important that from the beginning, you start thinking about disputes, because you fight, everybody fights. You fight with your siblings, you fight with your spouse, you fight with even your kids and your friends. So what makes you think that you're not going to fight with maybe a stranger or someone, your employee, or someone, a contractor, or anybody that you have a dealing with? And of course, when you're making arrangement for dispute resolution in your agreements, you can include things like negotiation, mediation, so that the first point of call is not just to rush to court, and you can save some money and also maintain your reputation. Because once it goes to court, it becomes a public case, and anybody sitting down there would listen. And I don't think I've ever seen any case that went to court where both parties came back as friends. So once you go to court, there's no more room for friendship, and that's not good for business. Sometimes you have fights in businesses and you still want to maintain that business relationship. You still want to be friends with that person. It might not have worked out this time, but it may work out in another deal. So it's important that you choose a dispute resolution mechanism that helps you not just to resolve that dispute at that moment, but also to maintain your business relationship for future businesses. And of course, IP ownership clauses. Daphne has talked about that extensively. So let's do some practical. You can type in the chat box. What do you think about this clause? This is a termination clause, and I've drafted it like this. Either party may terminate the agreement upon written notice. What do you think is the problem here? So it's vague, it lacks timelines, there's no reason, no implication, nothing. It just says either party may terminate the agreement upon written notice. So it's not also just about writing contracts or writing agreements. It's about writing agreements that are effective, that are clear, that are enforceable. Now, how about this clause? Now, this clause says Either party may terminate this agreement by providing 30 days written notice. The notice shall be deemed received first, immediately if delivered by hand. Second, 1 business day after transmission if sent via email with confirmation of delivery, or 3 business days after posting if sent by registered mail. Now, if termination is due to a breach, the non-breaching party may terminate immediately and seek compensation for damages incurred. Please type in the comment section. Tell me if this is sufficient. What do you think about this clause? Do you think this is a good clause, a good termination clause? Do you think this has everything that it should have? I hope I'm still being heard. Just yes or no answer. If you think we're good to go, fine. If you think something is missing, okay. Thank you, Deborah. Deborah thinks it's a good clause. Okay, so Bolanle thinks it's not a good clause. Unfortunately, I won't be able to let you air your views as to why you have said yes or no. But I'm going to agree with Bolanle. And it's not something, and Deborah, you're not wrong. Honestly, if I were a fresh law graduate from the university, I'll probably just grab this and think that it's sufficient as well. But over the years, with the experience comes some information that you don't learn in school. There are some things that you don't learn in school until you see them play out practically. And that's when you learn some of these things. Now, I'm going to just tell you some of the few things that are not here. First, so after termination, what happens if, for example, I've done part of the work that you want me to do, and then we end up terminating it halfway? What happens to the payment for the work that I've done already? It doesn't say. Won't I get paid for that? Does it go to charity work? Yeah, someone said no reason. No reason for termination. Actually, you can terminate a contract for no reason. You're just not interested. And you can include that. It says either party can terminate. You don't have to have a reason. Once you've given 30 days written notice and say, I'm no longer interested, you're not interested. And that's allowed. So it doesn't have to be that there's one big reason why you're terminating. That's what termination clauses are. It may just be that the work is stressing you. You're not interested anymore and you want to terminate. And that's allowed as long as you say that you give the conditions for terminating. But one of the major things that is wrong with this clause is that it doesn't make provision for what happens after termination, what happens to accrued benefits, what happens to job that has already been done, can it be prorated, how does all that happen? So let's just move forward because I think I've spent so much time on this already. So let's look at this payment clause. The client will pay for services rendered within 30 days. So what is the problem here? This alone is very ambiguous. You will not get your money. You will get your money because, of course, it doesn't specify any invoicing, penalties, or even confirmation. Now, but it doesn't mean that it's not bad. This is a basic clause, honestly. The client will pay for services rendered within 30 days. But within 30 days of what, maybe starting, within 30 days of delivering the job, within 30 days of whatever, it doesn't say. But look at this. The client agrees to pay 10 million naira within 30 days of receipt of an invoice. Invoices will be sent via email to the client's designated email address, and in the absence of confirmation of receipt, will be deemed received 2 business days after the email is sent. Now, payments must be made via bank transfer to blah, 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 blah. And then late payments will incur a 2% monthly penalty and all of that. Trust me, this can be drafted way better than this, but I just put this here just to give us an idea of what I'm trying to say. Now, this clause is fantastic. It's not perfect, but it's fantastic. It tells you how much you're supposed to pay. It tells you when you're supposed to pay. Now, sometimes people stop at within 30 days of receipt of an invoice. And I like to say that, how do you know that I've received an invoice? You have sent it. The only thing you can know is that you've sent that invoice. You can't know if I've received it. So sometimes I don't even use the words within 30 days of receipt of an invoice. I use words like that tend to fall on the side of after I've sent an invoice, because I know when I sent the invoice, but you can claim that you never received it, you know, right? But now, if I use something like this, I go ahead to say that, of course, it's assumed that you've received it automatically. However, if you don't acknowledge receipts of that invoice, it will be deemed that you've received it within 2 business days of me sending you that email and all of that. So I hope we get that. Let me move on. So what are some of the contract mistakes that can cost you? Of course, using templates blindly. Severally, my goodness, you have no idea how many times we've had to deal with this. Someone just randomly goes on Google, gets a template. In fact, the worst part now is people go to ChatGPT and ask it without the right prompts. Of course, I think you can even use ChatGPT to draft some reasonable contracts, but you have to know what to say to ChatGPT in terms of jurisdiction, in terms of where it's drafting from and all of that. But now people just go online, get templates for contracts that maybe the jurisdiction is in the US and all of that, and they just use it like that. Honestly, no 2 cases are exactly the same. Even when you have legally drafted templates like what we are offering for this webinar, you still need to tailor it to your particular needs. You still need to tailor it to your particular business and, of course, the jurisdiction. Now, ignoring governing laws, especially jurisdiction. Jurisdiction means where the seat of the transaction or the seat of the transaction. Let me use that. I think that's easier to understand. Ignoring that where is this transaction happening? What are the laws applicable in that area? If there is a dispute, what would happen? I mean, we've reviewed on a higher level, we've seen transactions that both parties and both companies are Nigerians, and they have put their seat of arbitration or dispute resolution somewhere in London. What are you going to London to do? What happened to Lagos and all of that? And of course, vague language leads to misinterpretation and disputes. People think that when you have contracts I've seen contracts that I'm like, sorry, what's the meaning of this word? I said, I don't know. I just saw it in one template. And just so that it can sound more legal and all of that. So because you want something to sound legal, you use verbose language that even me as a lawyer, I cannot understand. So simplicity is the way to go, even as lawyers. In fact, I'm very huge on keeping it simple, honestly. Then we used to have this acronym my lecturer uses in school, and he calls it KISS. Keep it straight and simple. Honestly, keep it short and simple, sorry. So I like things to be very clear. So don't use vague languages for your contracts. And then the last mistake is leaving your job to do mine. Your job is to run your business and to grow it. So you should always get legal advice to handle the legal aspects of your business so that it doesn't cost you more than that. So what are the steps to negotiating and drafting effective contracts? First, when you are having any dealing with anybody, you're discussing any business, even when you're trying to employ someone, that is also an agreement. That is a business dealing. So whatever dealing you're having with someone, the first thing you should have in your mind is use plain English and clearly outline all the terms in writing. What have you agreed upon? This person has agreed to do this, and I have agreed to do this. I've agreed to pay this person this person has agreed. Everything that you've agreed, put them in writing in plain English. Don't try to be too smart. Put them in plain, understandable English. Then during that discussion, ensure that you talk about payments, your expectations of that service or product, the deliverables, what's the person delivering? What is the tangible thing that will make that business deal a success? What are the timelines involved? If you want someone, for example, to design a graphic for you, can that person take 1 year and deliver in 2 or 3 years' time? Discuss the quality of what you want, discuss the rights and liabilities, discuss, of course, dispute resolution and IP ownership. Next, focus on protecting your business interests. Don't get carried away. Whatever you're discussing, have it at the back of your mind that you want your business comes first, and whatever you're discussing should favor you, not just the other person. And then, of course, lastly, have your contracts drafted formally and reviewed by a legal professional. So at this stage, what you do, you talk to your lawyer and you pass your notes, the notes that you took in the very first stage to that person. It helps the person to understand because the person is not sitting there in your meeting, except for big companies that have in-house lawyers or serious, I mean, there are some founders and entrepreneurs that from the word get-go, they get a lawyer on their team. Even when they are recruiting people, the lawyer is sitting down in those interviews and negotiating all of this with them. So except the person is sitting in that meeting with you, the person would not know what has been discussed and what has been agreed upon. And so it will be important for you to pass your notes along to the person. So how can effective contracts drive growth? Because that's exactly the essence of this presentation. Number one, it protects your cash flow. Like we talked about a payments contract. I dealt with a case where a caterer got a contract from a big company and it was like a big break. Like imagine a Unilever giving you a contract agreement to supply maybe breakfast and lunch every day for their staff for a month. I mean, she jumped into this, borrowed money without any deposits. And I mean, I don't mean it's not Unilever, please. It's not, I'm just using them as a case study. So, but this was a very big company. She jumped on it, borrowed money, got everything that she needed, kept supplying breakfast, lunch, everything. At the end of the month, they didn't renew the contract. She continued, she was waiting. She didn't get payment the first month. Second month, no payment. Third month, no payment. And interest was accruing on this money that she borrowed to do this contract. Of course, she needs money and she doesn't know how to get it. It was so bad that she didn't even sign the service agreement with the company before she started delivering this. And of course, it was because of the whole payment thing that she wasn't enthusiastic about the contract again and they didn't go ahead to renew. But things can get really messy and so fast. Things can get really messy really fast. So for you to protect your cash flow, because there's no business that will survive without cash flow. Your business needs cash to survive. So if you're doing the job and you're not getting paid, then just shut it down. You're not doing anything. So you can use contracts, effective and binding contracts, to protect your cash flow and of course avoid costly disputes. Now, when I talk of disputes, people don't know how much disputes can cost them. It can cost you so much. You can pay so much in damages. You can pay, even before the damages, you're paying a lawyer, you're going to court, maybe someone has sued you for non-performance and all of that. You're going to court, you're in court for 2, 3, 4 years. You're spending so much money and nothing is coming out of it. You've lost the job, you've lost the business relationship, you're losing money. So disputes can really be messy. So you want to have contracts that helps you to avoid expensive disputes. And this is how you also use it to drive growth. And safeguarding your trade secrets and innovation, we talked about that in the intellectual property presentation. And of course, it limits unreasonable and unhealthy competition. Now, let me dwell on this a bit. In your employment contracts, you can have things like non-compete and non-solicitation agreements, clauses, so that people don't just your employees don't just wake up. For example, you're doing something and your employee just wakes up and leaves the company today and goes to the exact next shop beside you and sets up exactly what you're doing. So you can use the employment contract to limit all those kind of unreasonable and unhealthy competition. Or they get up and then they start poaching all of your staff. And if you can use your contract of employment to protect yourself from that. And if they do that, you can proceed against the person by going to court to get remedy. And of course, having effective contracts attracts investment because everybody likes to do contracts with people who know what they're doing and have their books in order. So what are your next steps? This is already 9:25, so I'm rounding off. Sorry for taking your time. So what are your next steps? Review, as a business owner, review all your current dealings with third parties. I'm talking about your employees. A lot of business owners don't see the need why they should have employment letters or employment agreements with their employees. And this is very critical. You're fighting with them every day. Someone wants to take leave for maybe wants to take 3 months paid maternity leave, and you're saying we don't do that here. It's not like you have any policy or anything that you have it written is not in the agreement, or someone wants to. I mean, there's so many scenarios There's so many scenarios that I've talked about from the beginning of this presentation, but let me just focus on what is on the screen right now. So your next step is to review all of your current dealings with your employees, your vendors, your suppliers, whoever is influencing for you, your social media managers, your contractors. In fact, when it comes to even the social media management experts and creatives, someone that is in your employment, what they create, how do you protect and ensure that it is for you and it's not them, but then they don't go about passing it off as their work? Fine, it's their work, but under your employment, do you have agreements that says that whatever they do under your employment belongs to you? Automatically, this would apply, but it's always easier when things are spelled out like ABC so that everybody knows and understands this thing. It saves you a lot of headache, honestly. So review your dealings with everybody, your contractors, everybody, and identify possible loopholes. Now, when I say loopholes, it's not necessarily something bad, but just to identify opportunities to use contracts to structure your business and make everything work seamlessly without giving you headache. Identify where you're having headache in your business and see how you can use contracts to make it better. I mean, it's always best to engage a professional to assist with this. Just get someone on your team to assist with this. Then work with a legal professional to draft or update, when you've identified all of the things that you need, to draft or update contracts with clear and enforceable clauses, establish a contract management system, review regularly, and create standard templates for things that you have normally. Maybe you always engage contractors to do one or two things for you, and you need, or maybe IT solutions providers, and you need a standard, maybe service level agreement that's, or a standard non-disclosure agreement that you can always give people that come to work for you or do things for you to sign. You can have those as templates that you can always share with everyone. It doesn't have to be a one-off tailored written contract all the time. And of course, join our community of strategic entrepreneurs if you have not, and stay updated on contract best practices, new laws and regulations that may impact your business. So that's the end of my presentation. I hope I'm not taking so much time. If you have any questions, please, as usual, feel free to drop them in the comment section. I'll take, okay, we have just 2 minutes, so I'm not sure if I even have time to take questions, but as usual, please drop your questions in the comments. If I can take them, fine. If not, we'll address them on the group chat. Thank you very much. Thank you, everyone. I don't know if anybody has any questions. Okay, so I can't see any questions. I want to take it that we are all gurus and that we've seen the importance of having contracts or using contracts for our businesses, or we've seen how contracts can be beneficial to our businesses. Yes, very much, of course. But except if I don't understand what do you mean by, is it legally permissible to get into partnership agreements with other companies as an individual, not a business? Definitely. There's nothing stopping you from being a partner with a company. Of course, you can partner with a company to maybe execute a project or maybe quote for something, or I mean, you can. It's completely legal. Both parties are capable of entering into contracts. If you look at what should guide you is look at our elements of contract. If you look at our 6 elements of contracts, where do you fall short? None. I don't see anyone. So it's very legal. Thank you. Okay, so I don't see any more questions. If you have any more questions and you're on the group chat, please feel free to drop them on the group page. And in the absence of that, we'll be calling it a night. It's been a wonderful time with you, and we'll converge again tomorrow. Tomorrow we'll be talking about HR practices and what you need to know, laws, policies, and procedures. And then, of course, licenses and permits. I reviewed the survey for registering for this webinar, and I realized a lot of persons were interested in the licenses and permits that applies to their industry. I won't be taking that personally. I have Mr. Akin Akindele, who is also a lawyer and a business consultant. He will be here tomorrow to take different licenses and permits that you're supposed to have as a business. And someone said the link to join the platform is not working. Interesting. Okay. I'll see to that. But let me just put the link here on the chat box now. Okay. So like I said, he'll be here to help us to talk about a lot of the licenses that are applicable to different industries and how you can go about getting them, including things like SCOMO, NSITF, ITF. I don't know. The scope of what he's going to talk about is a lot, but for different industries. And then, of course, we have Yetunde, a HR expert, who is going to be talking to us about human resource and human capital management. So just give me a minute. I'm trying to paste the link to the WhatsApp page, but someone said it's not working. I don't know if it's me. It's just 1 minute, please. Please, we've come to the end of the webinar.